Hi, everyone. I'm Mary Texera, and I teach in the Department of Sociology here at Cal State San Bernardino. Welcome to our, I don't know, 100th or so. It's not that many, but we've had quite a number of programs since about May in the wake of George Floyd's killing. We felt, many of us on campus felt very strongly that we needed to address this issue from our ivory tower. And so we have had many interesting programs. And the one today promises to be as interesting or more interesting than the ones we've had in the past. We're going to be talking about suing the police and qualified immunity. If you don't know what that is, I'm sure after about an hour or so, you'll get the gist of it. As always, we like to open the program with land acknowledgement. We are on land that in fact does not belong to us. And so we want to acknowledge the folks who are whose land it is. And so I am pulling this up now. So land acknowledgement is a formal statement that recognizes and respects Indigenous peoples as traditional stewards of a given geographic area and the enduring relationship that exists between Indigenous peoples and their ancestral territories. So having said that, we recognize that California State University San Bernardino sits on the territory and ancestral land of the San Manuel Band of Mission Indians. We recognize that every member of the California State University San Bernardino has benefited and continues to benefit from the use and occupation of this land since the institution's founding in 1965. Consistent with our values of community and diversity, we have a responsibility to acknowledge and make visible the university's relationship to Native peoples. By offering this land acknowledgement, we affirm Indigenous sovereignty and will work to hold California State University San Bernardino more accountable to the needs of American Indian and Indigenous peoples. So, proceeding with the program, we always, we want to be consistent. So we are going to talk a couple of items on good news, that is progress being made in the criminal justice system in regard to policing and new laws, etc. And one of the items that has come up is Measure J in Los Angeles was put on the ballot by the Board of Supervisors, 5-member Board of Supervisors, and that measure asked that 10% of the budget of Los Angeles County be devoted to diversionary programs, jail diversionary programs, as well as other social service programs. And eventually that money will come out of the budget of the Los Angeles County Sheriff's Department. So that passed overwhelmingly, and we do believe that it is a result of certainly the George Floyd killing, but also the defund the police, the slogan, as well as the efforts to examine police budgets around the country. Speaking of which, ex-President Obama, or former President Obama, just came out and said he thought that he does not like the defund the police slogan. He called it, I think, what did he call it? He called it a snappy slogan, which will get us nowhere. So there is that. And I think that was all that all the good news we have this week, but we're going to keep plugging along, and we'll get some more good news next week. I don't want to waste any more time. We're going a little short today. We're going to be ending at 5:30, which will include the Q&A. So I want to introduce, first of all, Professor Joanna Schwartz. She is Professor of Law at UCLA, And her specialization, as you probably saw from the flyer, she looks at police misconduct and litigation. So I'll let Professor Schwartz begin, and then we will introduce our next guest.
Terrific.
Thank you, Joanna.
Terrific. Well, thank you. Thank you for having us. And thank you to all of you for being here this afternoon to talk about qualified immunity. I think that if a year or two ago, Amir and I knew that we would be invited today to come speak about qualified immunity, I think that we probably both would be pretty surprised. I know I would, because qualified immunity is a doctrine that I've been thinking about for a long time, and I bet Amir's been thinking about for a long time too, but it's really only in the past couple of years, and really in the past handful of months since George Floyd's killing, that there has been so much focused attention on qualified immunity. So I wanted to spend my time today talking to you a bit of background about what qualified immunity is, how it's developed over time, and give you a sense of some of the ongoing debate about qualified immunity doctrine, what it does and doesn't do, and some efforts in courts and also legislatures to undo some of the effects of qualified immunity. So to explain what qualified immunity is, I think it's first important to go back a step further to make clear that since the years after the Civil War, Congress created a statute, enacted a statute called 42 USC Section 1983. It's referred to as Section 1983, which gave people a right to sue government officials for violating their constitutional rights. And the statute sort of lay dormant for almost 100 years. But in 1961, the Supreme Court made clear that people could use that statute to sue police officers in federal court for violations of their constitutional rights. And the Supreme Court has sort of understood and explained from the beginning, and Congress has said it too, that these lawsuits, these damages cases, are meant both to compensate people whose rights have been violated and also to deter future misconduct. But 6 years after the Supreme Court recognized that right, in 1967, the Supreme Court limited that right to relief by creating a doctrine called qualified immunity. And at the time, they explained that qualified immunity should protect officers from liability if they make good faith mistakes, and talked about this as a necessary protection so that officers wouldn't be held personally, financially responsible if they make good faith mistakes. If they arrest someone thinking it's proper to arrest someone and later finding out it's not, they shouldn't have to pay damages for something like that. Over the past 50 plus years, the Supreme Court has made this qualified immunity defense stronger and stronger. So in 1967, it was just to protect officers from liability for good faith mistakes. In 1982, the court said, we actually don't want to even think about the officer's good faith anymore because it takes too long to figure that out during litigation. And we want to dismiss these cases early to protect officers from the costs and the burdens and the distraction of being named a defendant in having to be deposed and give other evidence and testify at trial. So officers have to be protected from liability under qualified immunity unless they violated what the court called clearly established law. So then everyone wanted to know, what does clearly established law mean? Mm-hmm. And the court has spent the last 40 or so years explaining the answer. And they keep making the standards more and more difficult to meet. They have said that except in extreme circumstances where there's obvious constitutional violations, and they only ever twice found an obvious constitutional violation, you have to find a prior court opinion that has held this conduct to be unconstitutional. And then the court has said, you have to find a case not only that is held sort of a general principle to be unconstitutional, like you can't use force against someone who is not resisting. Instead, the court has said you have to find a case with facts that are almost identical to the facts in your case in order for the law to be clearly established. So one example of that that I think illustrates the point is a case called Baxter versus Bracy, which was a court decision where the court, the person had been was suspected of burglaring a house. And there was officers who had a dog, a canine dog, who was helping them find this person. He sat down with his hands in the air. He had surrendered, but the officers released the dog on him anyway, and the dog bit him and hurt him. The court ultimately concluded there's qualified immunity for the officers, even though it was well understood that you can't use force against someone who is not resisting, as this guy was. Even they even had a prior decision where that very court had held that it was unconstitutional to release a police dog on a person who was lying down and having surrendered. But the court said the factual distinctions between a person lying down and a person sitting up with their hands in the air were significant enough to mean that the law wasn't clearly established, and these officers were granted qualified immunity. And unfortunately, I could tell you a million of those stories, case after case after case, of people whose claims against them were dismissed, not because what the officers did was all right. In many of the cases, the court assumes that the conduct was unconstitutional, but because there wasn't a prior court decision with sufficiently similar facts to put those officers on notice. Now, why do we have this protection? Well, I've given you some of the reasons why that you can see in the court's opinions. They want to protect officers from financial liability, from being personally financially liable for these settlements and judgments in lawsuits, and because they want to shield these officers from the burdens and distractions of being sued. And today, in the midst of growing criticism of qualified immunity, these arguments are being made again. And if you look at what Republican leadership in the Senate and law enforcement union leadership and other public commentators are saying, they will say sort of the same kinds of almost talking points again and again, that without qualified immunity, officers will be bankrupted for reasonable mistakes, and that no one will ever want to be a law enforcement officer again. And so, you know, we will not have a police force if we do away with qualified immunity. I've done a lot of research about qualified immunity and what impact it actually has. And my goal with that research has been to try to understand, to take seriously those defenses of qualified immunity and understand whether they actually are true, whether we do need qualified immunity to protect officers from bankruptcy when they make reasonable mistakes. And my research suggests that the most common defenses and understandings of what qualified immunity does are inaccurate. Officers are not held personally financially responsible for settlements and judgments in police misconduct suits. I have looked at 6 years of police misconduct settlements and judgments in 81 jurisdictions across the country. And in those cases, I found that fewer than 1% of cases had any payment at all made by an officer, and the dollars paid to plaintiffs in these cases, 0.02% of those dollars came from officers. This is because every state, including California, has indemnification statutes that obligate local governments to pay settlements and judgments that are entered against their officers. In California, local governments have to pay those settlements and judgments so long as the officer was doing their job in the course and scope of their employment, which they are doing even when they violate the Constitution. And so those statutes and rules protect officers from personal financial liability. Officers also aren't being found responsible or they aren't violating the Constitution when they make reasonable mistakes. The way that the Constitution is currently interpreted by the Supreme Court, officers don't violate the Constitution when they search the wrong person, arrest the wrong person, shoot the wrong person, so long as the mistake that they made was reasonable. So the Constitution itself already protects officers from any consequences in the courts for reasonable mistakes. So if qualified immunity if getting rid of qualified immunity wouldn't do the terrible things that defenders of qualified immunity say that it would getting rid of qualified immunity do anything at all? There are people who are raising signs in protest that we should end qualified immunity. Congress is considering bills to end qualified immunity. Advocates are going to the Supreme Court asking the court to end qualified immunity. State governments around the country, state legislatures are contemplating ending qualified immunity. And so it's important to know what, if anything, would happen if qualified immunity were eliminated, if there already are constitutional protections protecting against reasonable mistakes. And there already are indemnification statutes that protect officers financially from any consequences of these cases. My point of view, based on the research that I've done, is that ending qualified immunity will not flip the switch of police accountability and make the entire world of police accountability change. It is one part of a much broader system that needs to be reconsidered. However, ending qualified immunity would do a lot of important things. And I want to just end with what those important things are, in my view. First, it will provide a way for people whose constitutional rights have been violated to receive compensation for their losses. Right now, people who have had their constitutional rights violated can have their cases dismissed simply because there's not a prior court decision with precisely the same facts. And ending qualified immunity would end those injustices to those people. Second, though ending qualified immunity would stop sending the message that courts and the Supreme Court are sending through these cases, that police can violate the Constitution without consequence. Supreme Court Justice Sonia Sotomayor said that the Supreme Court's qualified immunity decisions send the message to police that they can shoot first and think later. And ending qualified immunity would stop courts from sending that message in that way. Ending qualified immunity would also allow for more clarification of what the Constitution allows and requires. Courts now can grant qualified immunity without deciding whether an officer's conduct was unconstitutional. So ending qualified immunity would mean that courts would have to be clearer about what violates the Constitution. And some law enforcement groups argue that ending qualified immunity would actually help them because it would make clearer what the state of the law was so that they could better train their officers and write constitutional policies. And finally, the research that I have done suggests that qualified immunity doctrine makes civil rights litigation far more costly and time-consuming and complex than it would be without the doctrine. Qualified immunity, if it's denied, it can be immediately appealed, that decision, and that can take an extra year or more. Actually, Amir could tell you it could take many more years for those qualified immunity issues to be decided. It's hard for anyone to understand what qualified immunity means. And for lawyers, it means that they have to really study up and learn about these cases and what qualified immunity means. Ending qualified immunity would end that complexity. I think it would mean that more lawyers would be willing to take civil rights cases. They still would have a lot of reasons to decline cases. They would still decline most of the cases that they take. But ending qualified immunity would get rid of one significant barrier to these cases and focus more attention to what should be the critical issue in these cases, which is whether the Constitution has been violated. So those are my thoughts about qualified immunity, what it is and what it does. And so I'm happy to pass it along to Amir.
Thank you. I'm sure there'll be lots of questions. I have about 4 or 5 myself, but we'll wait. We'll wait until after. It's my extreme pleasure to introduce Amir Ali, who is, miss my page here. Amir is Deputy Director of the Supreme Court and Appellate Program at the MacArthur Justice Center, and he oversees the organization's DC office, which is, he's actually calling in from a bunker right now in DC, so I'm sure he'll tell you all about that. He also directs the Criminal Justice Appellate Clinic at Harvard Law School. So with that, Amir, please go on.
Thank you, Mary. Thanks to the school for inviting me to chat, and thank you for associating me with Joanna Schwartz, who, some of you may not know this, but Joanna is the guru of all gurus when it comes to not just qualified immunity, but especially qualified immunity. And
well, we were hoping that she would use that term, but she did not. We asked her not to be humble, but thank you for saying that.
Yeah, so the organizers chose well when they chose her, at least. So yeah, I focus on litigating civil rights cases, meaning, when people or the families of people who were victims of constitutional violations want to try to hold folks accountable, government officials accountable. They can bring lawsuits, as Joanna described, under a section called Section 1983, which was part of a very early Civil Rights Act. And I specifically litigate in appeals courts, meaning before panels of anywhere from 3 up to 18 judges for a case that I argued a year ago in a police shooting qualified immunity case. And we discussed the legal issues. And so I can speak a little bit to what it's like to litigate these cases and the doctrine generally. But let me return to a couple of things that were mentioned both by Joanna and by Mary in her introduction. Joanna mentioned that we've been thinking about it, her and I thinking about qualified immunity for some time, and would have been surprised a year ago if we were asked to speak about that. And that's completely true, but not due to any sort of new importance of the issue, new attention for sure. But for decades, if you asked any civil rights attorney what the biggest burden to bringing suits under Section 1983 to hold government officials accountable is, they would have told you qualified immunity is the biggest obstacle. I litigate civil rights cases full time for a private a foundation, a nonprofit, but most civil rights attorneys or personal injury lawyers are weighing, whether to take a civil rights case or potentially a medical malpractice case or a personal injury case. And they really have to weigh the risks of litigation and the strengths of the defenses and all of that into their calculation into whether to take a case and the likelihood of success and the availability of this sort of defense that I'll describe a little bit more, but that Joanna already laid the groundwork for. Is immensely important to that calculation, and means that a lot of these cases just never get brought in the first place, including cases that we often and today are very much rightly so focused on cases involving murder by police officers and shootings. But remember that the vast majority of civil rights violations that happen aren't shootings or murders. They're happening all the time on a lesser scale. And the idea that, stops, searches, frisks, other abuses that are happening every day, by the thousands, unwarranted intrusions on people's lives, the idea that these would be litigated, given the limited damages and also the availability of defenses like qualified immunity is very unlikely. And that's really an important thing to keep in context. The second piece I'll come back to in the introduction is just Mary mentioned that this conversation we're having was started in the wake of George Floyd. And, I think stepping back, it's possible to kind of contextualize this as a piece of questions that should have been asked in the wake of George Floyd. And, I think everybody who's listening has seen the video, or at least the images of Derek Chauvin. His knee is in the back of Black man who's face down on the ground, struggling to breathe. But one thing that's really, there's a lot that's shocking about the video, but one thing that's really striking about it that I noticed immediately was how unfazed he was, right? He's got his hands in his pockets the entire time. He has sunglasses sitting peacefully on his head the whole time. He knows he's being videotaped, right? I mean, we know now, and everybody is rushed out to say that this was murder, and that's right. That's certainly true. But this is a man who was committing murder and knew he was being videotaped, but didn't seem to care one bit, right? And we don't usually think of murder that way. And so, what struck me instantly was that, politicians were on both sides of the aisle were rushing to say, this is murder, this is murder. But that's not the right question. Of course, it's murder. The question I think that we should have been asking is, why does this person clearly think he can get away with murder? And I think Joanna is absolutely correct and well positioned to say that qualified immunity. I'm sorry if you can all hear my dog barking, but that's why I'm in the bunker in the first place. Qualified immunity is one piece of the answer to that question, and only one piece. There are a lot of other levers we need to revisit for accountability, and maybe even more direct accountability than qualified immunity. Definitely more direct accountability. But one of the answers to the question of why does a police officer act like he can get away with murder is that it is factually true. The answer is that because they can get away with it. And qualified immunity quite explicitly says that. It is not enough to come into a civil court as a family of somebody who has been murdered by a police officer and prove that the officer murdered your relative. That's not enough to recover. You can prove that this police officer did, as Joanna kind of highlighted, something that no other reasonable officer used, force that no other reasonable officer would have used in the circumstance. And that is not going to be enough to hold the officer accountable. And that's quite remarkable in the law. It is usually the case that people are expected to follow the law. I mentioned, attorneys who might bring these cases could be weighing things like medical malpractice cases or personal injury cases. Generally speaking, what you have to show when you come into court to recover and hold someone accountable is that they did something that violated the ordinary standard of care, something that no reasonable person in their profession would have done, right? That's what negligence generally means alone. And as Joanna mentioned, that is the standard under the Constitution and under Section 1983 for holding police officers liable. It should be the standard. It is the standard for showing that they violated the law. But because of qualified immunity, even officers who do something that no reasonable officer would have done, who use force that no reasonable officer would have used, or that was objectively unreasonable, as we call it in legal terms, even those people escape any sort of accountability. And so there's this extra level of protection that is given to them. Joanna mentioned the standard for qualified immunity is to show that a police officer or government official violated clearly established law. She gave the example of Baxter v. Bracy, and I'll give a couple of other examples just to give a real sense of how these arguments are made by government officials and their attorneys in court. There was a case in the Ninth Circuit, the jurisdiction that governs most of the West Coast, the Federal Appeals Court, involving some officers who were executing a search warrant. Joanna will know this case for sure already when I'm mentioning it, but it's a very good example. The officers are executing a search warrant and they're authorized to seize property as part of the warrant. There's already been a judge who's said that there's reason to believe a crime was committed and you can seize the proceeds of crime, and they seize multiple hundreds of thousands of dollars. And in the process of doing so, they pocket, I think it's about $50,000. And there's some rare coins involved and some cash involved that they pocket. And afterwards, the people who had the property stolen from them sue and say that violated our constitutional rights to steal in the context of executing the search warrant. And the Ninth Circuit says, well, there's no clearly established law saying that officers can't steal in the course of executing a search warrant. And that gives you a sense, I think, of how ratcheted up this idea of clearly established laws. They even said it wouldn't obviously violate someone's constitutional rights for it to do so. And this really is what we're litigating. I think it's really astonishing to people to hear that these are the arguments that are being contemplated and considered in court. I mentioned to you a case involving 18 judges. This was in Texas. Arrogate a case last year, and it was a police shooting case. And the facts, as the court had to accept them, were involved shooting a 17-year-old boy from behind. The boy was suicidal and was holding a gun to his own head. And under the facts, the boy was not facing the officers. The officers knew he wasn't facing them, didn't move, and they decided to end the situation by just shooting him. And the debate we were having in court with me and 18 judges and my opposing counsel was, if we assume that that there was no threat to the officers, and if we assume that even the officers couldn't reasonably have perceived a threat from this 17-year-old boy, did it clearly violate the law to shoot him? Just pause for a second. Like that question is absurd, right? No threat, could not even reasonably perceive a threat. Did it violate the law to shoot him, right? And that is the argument that's being had. And the arguments that were being made were, well, there hasn't been a case before this on point that involved a person who was facing the other way with a gun to his head. It actually turned out that there had been a case that was involved that way. So they had to say, well, that case was in an apartment building. This case took place outside. And, you know, it's this very absurd line of arguments. You know, think about it to kind of give maybe a different analogy. If you're a parent and your kid is in school and is bullied, and you go to the principal as the parent and you say, you know, my kid was bullied. He was hit with a stick in the playground. And imagine the principal, who's, you know, the judge here, says, oh, okay, well, just tell me some more details. Did it happen in the playground? What was it, in the first recess, the second recess? What time of day? It was a stick. It wasn't a rock. And he says at the end, after asking all these questions, he says, well, look, it was completely outrageous that this kid bullied your child and violated every rule in our book. The problem is there's never been a bully who's hit a kid at that same time of day, you know, with a stick instead of a rock. And so, you know, who would we be to hold this bully accountable when we haven't held bullies in the past accountable in that same set of context? Right? You'd say, what is this? This is a bizarro world, right? Why is this an acceptable line of argumentation? And that's quite literally what has to take place to litigate these cases. I'll just come back to the case I mentioned that went up to the 18 judges of 18 federal judges to decide this issue. And by the way, they split. We ended up winning the case, but it was an 11-7 decision. And so there were 7 judges who thought that didn't violate, that the qualified immunity was warranted there. That case was litigated on the qualified immunity issue for just about a decade. And the family and Ryan, the boy who was shot, who's still alive, who's just severely injured, had to put up with nearly a decade of litigation just on this question of whether shooting violated clearly established law, all of which, you know, got in the way of ever having a trial against these officers who he sought to hold accountable. I think I'll pause there, and that way we have plenty of time for questions.
Great, Stan. I'm going to I'm going to get in the front of the line before you start asking questions, because I've got several.
Can I make a statement first?
Absolutely, absolutely.
Fantastic. Amir Ali, you stole my thunder. As I tell Professor Schwartz, that the two things that were just amazing, and you touched on both of them, and Chauvin on the neck of
George Floyd.
George Floyd, just incredible. And you hit the nail on the head when you said, because of Q&I, he has no problem doing so. And I, as she was talking, I wrote that down so fast, and then you mentioned it, and that's so true. I think the biggest issues that we're dealing with is not even the law as much as it is the ability to circumvent the law. So these officers are circumventing the law because they know they can. And we look at these old movies and we see these Southern sheriffs and so on, you know, big old bellies, glasses, you know, and the hat on, and you look at it and you think, you know, this guy's violating every law in the books, and you're looking at it and you're just kind of laughing at these old movies. But the truth of the matter is, it's happening in real life, and I've seen it happen in real life. When I go back in the South, I get pulled over and I can't believe what they do and how easily they do it. And you hit the nail on the head when you said that when the professor said, stop sending messages that police can break the law. It's got to happen. It's got to happen. And the second one is courts would have to be clear in defining the law. Those two things are so powerful in what we're talking about, because we truly need to have some kind of change. And I'm so glad both of you are here today to talk about that change. We will go in Q&A, and Mary, go ahead.
Thank you. I totally agree with what you just said, Stan. This is extremely important. And I don't think I've ever heard Chauvin's demeanor described in quite that way, Amir, but you're absolutely right. There was just a lack of affect. You know, he was just, it was almost as if there was a bit of swagger, you know, with the hand in the pocket, but also it was almost like he was in a trance or something. I don't know. I was very, very equally as shocked over that as the murder. I think I have to get clear in my mind the difference between civil litigation and criminal litigation. So if you all could just maybe clarify that, because I know a lot of families are getting big payouts, but that's in civil court. And does qualified immunity apply to civil court in the same way it does in criminal court?
So it only applies in civil cases for damages, for money. It does not apply in criminal prosecutions. There are other aspects of the criminal process that create, you know, different kinds of protections, but qualified immunity is related to civil rights lawsuits in civil court seeking money.
Okay, great.
Yeah, and I think I just
Amir?
add to that.
Okay.
Yeah, I think that's exactly right. And I just add to that you know, both Joanna and I have kind of mentioned that qualified immunity is only one piece of this, and you could, I think there are really like three main tools I think of for accountability, right? We have our criminal justice system, and I think we all see that that's repeatedly failing us too, right? Either
Yes.
officers are not being charged, or they're not being indicted by grand juries, or they're not being held accountable by the criminal justice system because the jury acquits at the end of the day. A second tool would be disciplinary, internal discipline. And we see that failing too. The culture of policing is not policing itself. And we see the revolving door of bad police officers and no systemic changes to the culture. And then there's this additional tool or lever we have, which is the civil system. And I don't think I can say it's the most important of them. But one thing I can say is that I think it's the only one of them that the individual, the victim or the victim's family has or should have completely within their own control. The idea of the civil justice system is I get to hold you accountable. The other ones, the criminal justice system depends on the intervention of a prosecutor, of a grand jury, disciplinary system, and depends on the police departments. Civil justice system is supposed to be where we can hold the people who violate our legal rights accountable. And so that makes it important in its own right.
And so to piggyback on that is
can I just follow up real quick,
Okay,
Stan, while I have it in my, and you all hear my dogs too, and I'm not in a bunker. Sorry, so sorry. So those 12 jurors in the Rodney King in Simi Valley, California, in the Rodney King case, decades ago, obviously, but this was the first or the last time I think we had 4 officers actually on trial for the beating of Rodney King. And so the criminal case in Simi Valley was totally dependent. There was no argument about qualified immunity. It was totally dependent on the feelings of the jury, as opposed to any sort of statute or any sort of Supreme Court decision, etc. Is that what we can assume?
Yeah, I mean, I think that there are a lot of, as we have said, there's a lot of barriers to relief in civil cases and criminal cases. And I think an important barrier to relief that is important to keep in mind is the jury. And that's true in civil cases where money is being sought. It's true in criminal cases as well. Juries ultimately, what you have to get through all of these different barriers to relief to get to the jury. You have to have enough evidence in a civil case to convince the judge that you actually have, claims. You have to prove constitutional violations, and the standards are very hard. You have to get past qualified immunity. And we said that's very challenging. And then what you get at the end of all of that is to bring your case before a jury. Mm-hmm. And juries, I've interviewed, I was a civil rights lawyer myself, and I've interviewed a lot of civil rights lawyers, and they will say, I mean, I agree with Amir that, they talk about qualified immunity being a real challenge to relief in this case. Of the lawyers that I've interviewed, they will as often say that juries are a challenge to relief in these cases. Cases don't often get to juries because they're either settled or dismissed beforehand. But juries can be very tough in these cases. And depending on where you are in the country, they can be really, really, really tough. In LA County Courthouse, civil rights lawyers will tell you you're going to get a pretty fair shake. In
Simi Valley,
Dallas, Tallahassee, you are facing a jury pool who, may be very, very skeptical of your case.
Yeah. Well, one of the reasons the Simi Valley location was chosen, because it should have been in Los Angeles County Court, and Simi Valley is in Ventura County, is because there are more police officers in Simi Valley per capita than any place else in California. And so it was almost ensured that it would be, the case they'd be found not guilty because it was just so far away, and these folks are all pro-cop. Are you hopeful about the future? Does it depend on administrations, I guess? We've come out of one administration, which was very conservative, among other things. I mean, among many other things. And so we're seeing maybe a more progressive administration coming up. How, look at your crystal ball and tell us what the future is. And Amir, I'm going to let you take that one.
Okay.
Since you're right in the belly of the beast over there.
Yeah, sure. Am I hopeful? Well, I'll narrow the question to, am I hopeful about reforming qualified immunity? And at the national level, my answer is no, but we'll keep fighting. I think actually the Biden administration, future Biden administration, has already made pretty clear that qualified immunity is not on their agenda,
Yes.
and is not going to be one of the changes that he's fighting for. It's actually quite a disappointment because there was bipartisan, actually they call it tripartisan support in Congress to eliminate qualified immunity. Justin Amash had introduced a bill in the House that was sponsored by at least one Republican and a number of Democrats. And there was a bill introduced in the Senate by a Republican senator that wouldn't have abolished it altogether, but would have made really serious headway towards liability and accountability. And the efforts completely stalled in the Senate, but you'd think that if you, and the reason for that was President Trump's signal that qualified immunity was a deal breaker, as he was meeting with all the police unions and they were telling him qualified immunity should be a deal breaker. And so it is quite disappointing. I think if you had an administration where it was a priority, it's not out of the question that you could get to the votes, even with a divided Senate.
Yeah. You concur, Joanna?
I'm
sorry.
The Supreme Court has some really. Oh.
No, please go ahead.
Joanna, do you agree?
No, you keep talking. I do agree, but you keep talking.
I'm sorry. You were frozen for a second, and I thought you were done. So.
Oh, I'm sorry.
Go ahead. Please go ahead.
I'll just say one other thing, which is that a lot of attention's been focused on the Supreme Court because you have Justice Sotomayor on one side of the spectrum speaking out against qualified immunity, and of all people, you have Clarence Thomas on the other side of the spectrum, ideologically, at least typically, saying that he would abandon the doctrine of qualified immunity. And as a Supreme Court litigator, if I have Justice Sotomayor and Justice Thomas agreeing on something, I usually think I will win. This has proven to be a little bit more complicated, and there have been a number of cases asking the court to overrule it. Joanna's been very involved in those efforts, and they haven't taken the bite yet. And we can speculate as to why, but that's not a great sign, at least in the very short term.
Okay, thanks.
Yeah, I agree with your comments. I think that Congress, I doubt Congress will. I would be very surprised if Congress ended qualified immunity. I think there's a world in which Congress could amend qualified immunity, change qualified immunity, still have the doctrine. I mean, to be frank, as I mentioned in my comments, the argument about qualified immunity, the defense of qualified immunity is that we need it to shield officers from financial liability when they make good faith mistakes. I would say right now and here, I'm happy to have qualified immunity if it looks like that, because that's not qualified immunity. So if we can all get consensus that officers should be shielded from financial liability for good faith mistakes, and they want to call that qualified immunity, I'm game. Sounds good, but it's not what qualified immunity is. So if we could keep something that is called qualified immunity and have that be what it is, I would see that as an enormous victory. And I'd be happy to still have the term qualified immunity in existence. So I think that's the one way in which something could happen in Congress. I think that the Supreme Court has all sorts of concerns about whether they can reverse themselves and what it means to reverse themselves. And there's all of these arguments that they've been ruling in the same way for 50 years and they can't change course now. But as someone mentioned in the questions, the Q&A in the chat, the Supreme Court did a couple of weeks ago issue a decision called Taylor versus Riojas. And it was a case that has just terrible facts, horrifying facts of a person who was kept in a jail cell covered with feces for 6 days. And the Supreme Court held that you don't need a prior court decision with similar facts to make clear that that is beyond the pale, and they should have known better, the prison officials. On the one hand, as I said in the chat, that doesn't really, I mean, again, it should hardly be controversial that that is clearly unconstitutional. On the other hand, it's the first time in nearly 20 years that the Supreme Court has said that you can defeat qualified immunity without finding a court case with virtually identical facts. And so my prediction is that there will be many litigators and courts who rely on that case in the future to try to make the standards a little less difficult to get through. And the last thing that I would say is I think that there is really exciting and interesting things going on in the state level. There are civil rights commissions that I know of or I've testified before in Rhode Island, in Massachusetts, in Kansas, in New Mexico, in Mississippi, and I'm sure there's other places. In Colorado, they've created a way to sue under state law without qualified immunity. And so states really are where the potential action is, to my mind, on ending qualified immunity. And it's not just, I mean, California considered a change to our law that would have no qualified immunity for state claims, and it was defeated by the state legislature. New Mexico's, Civil Rights Commission is recommending that they do away with qualified immunity, and Kansas and Mississippi are considering this. So this is, there are places around the country that are thinking seriously about what to do about this doctrine. So I'm an optimist by nature, and I find things to be optimistic in what's happening right now.
Great.
Thank you so much.
Amir, you're not an optimist, I guess.
I usually
Go ahead, Stan.
One of the questions, or actually a statement, I believe this week an officer was charged for murder of a civilian in San Francisco. Are you aware of that case? Prospects for successful prosecution. And so you're right, things are happening at the state level, and that is such a good thing. And Professor Schwartz, you've been answering the questions, so that's a good thing. Thank you so much.
Sure.
And the one thing says, can something be done to a police officer who called a victim of a rape crime and told her he did not process her report because he thinks the story is BS, and that rape people don't act like her. So so that is why he did not file her report and did not try to do anything to investigate her report. To this day, nothing has been done about the report, but he said he's working on it. But it's not going to be a fast process. The report was made in October 5th. And I guess her real question is what can she do to make him do his job? Do you see the question?
I'm going to leave that one to Amir to answer.
Yeah, I mean, I want to be really careful not to give any sort of legal advice on what to do in a real circumstance here.
In general, though,
really just don't have the information that'd be needed to do it. And on top of that, like I said, I focus really on kind of high level appeals courts. So I actually don't know the answer to the question. I do know that it is immensely difficult to hold officers accountable, and particularly hold prosecutors accountable for their decisions, not to bring charges and things like that. So it can be extremely frustrating and difficult to get officers to do their jobs.
Yeah. And there are thousands of rape kits that are just lying fallow because, police officers or police departments don't see them as important. But what I would suggest, my piece of advice is not legal, but that we've got two sexual assault crisis centers in our area. One is the Riverside Rape Crisis Center, and the other is San Bernardino Sexual Assault. So I would suggest that the person who is frustrated because there's no action, that they should contact those folks who are used to working with police departments, and maybe they can get something done. You know, there's always a higher level to police officers don't have the final say so in which reports are going to get filed and which aren't. So, you know, you might have to go above that police officer.
And I had a question of my own. I wanted to go back on what Mary was asking about the civil cases. And my question is, after the civil case has been done and the officer's been found negligent and the monies are being passed around, who's passing the money around? Is it the officer himself, or is the organization he works for, the city, the county, the state?
When a settlement or judgment is entered against an officer, the check is virtually always written by the government, and it rarely comes from police department budgets either. So it's paid from central funds. The cities and states have indemnification rules. So rules about when the city will pay for the lawyer, for the officer, and also for any settlement or judgment. And if the city decides that they're obligated to make those payments, and they virtually always do, then the city writes the check.
Wow, and the reason why I asked that is because I pretty much thought that was the case. And so if the officer is in good graces with the department he's working for, there's pretty much no punishment other than don't let it happen again. And this person's got a pattern, so it probably won't happen again, and then they'll be sued again.
Yeah. I mean, I think that I actually have been thinking about this a lot, because I've been sort of thinking about what I think the system should look like and how it might work better to think about budgeting and paying for these suits. And if you think about the goals of these lawsuits being to compensate and then to deter, ultimately, I actually think that having this money come from having people whose rights have been violated be paid, know that they will be paid from central government budgets actually makes sense, because most police officers are not going to have the money to satisfy a settlement and judgment in these cases. And what I have found is, in the rare instances when officers are denied indemnification and told they have to go on their own, plaintiffs and their lawyers don't, tend not to pursue the cases, or they try to find somebody else who they can sue, who will be protected and indemnified by the government, because it's a lot of money and time to spend to pursue charges against someone who does not have the money to pay. But if we have a system where the central government is paying these settlements and judgments, we also need the system to work in a way that creates some financial sanction or other kind of punishment for these officers. And Colorado just passed a bill that's really interesting in this way. So what Colorado's law says is that the city will pay settlements and judgments entered against their officers. But if the local government finds that the officer acted in bad faith, so they have to look at the case and see whether the officer acted in bad faith, then the officer can be required to contribute 5% of the judgment or $25,000, whichever is less. And if the officer doesn't have the money to pay, then the city will pay the whole thing. But what I like about that approach is that it does create a financial punishment if an officer has been found to act in bad faith, but that punishment does not ultimately harm the person whose rights have been violated. They can still get the money that they are entitled to, which won't ever be enough probably to compensate them for what's happened or make that go away. But it does, I think, balance those interests in a way that I have been thinking a lot about and think makes a lot of sense.
Yeah, and I'll just add,
yeah, please.
The inverse is that right now we have, this is kind of implicit in what Joanna was saying, right now we have the worst of all worlds on that front. I mean, if the officer is held liable, they don't write the check, generally, almost universally speaking, even if there's a finding of punitive damages. This is Joanna's research that I'm plagiarizing here, but that in punitive damages, what that means is there's a finding by a jury that this officer acted maliciously or wantonly in using the force. So even if there's that finding, the city's going to write the check at the end of the day. And what qualified immunity adds on top of that layer is that actually the city just never ends up having to write a check either. So there's not only no sense of accountability on the part of the individual officer, but there's no feedback mechanism at all that might cause a city to start saying, okay, well, we ought to be careful about who we're hiring, and we ought to have training mechanisms. Just having this, I think one of the points Joanna is making is just having the city write the check doesn't guarantee a feedback mechanism if there's no kind of additional incentive there for the city to, one would hope the city's management of its own budget and looking at the cost of these suits and having this sort of culture in police departments would be enough. But right now we have a world where no checks are being written at all.
Mm-hmm. So what's talk me out of these massive awards being taken out of the police budgets themselves. We started off talking about Measure J, right? Where some monies are going to be 10% of the county budget is going to go to social programs. But what's wrong with because wouldn't these departments be more apt to change their policies if they were getting hit in the pocketbook?
So I think that it's something that we have to study more. Actually, the LA Sheriff's Department does have money from their lawsuits taken out of the LA Sheriff's Department's budget. So how well is that working? Let you all be the judge.
Okay, forget it.
For that. I mean, I think that I do think that, when I've interviewed risk managers in jurisdictions that do that, they do say it makes them think about it a little bit more. I think CHP, California Highway Patrol, does as well. But ultimately, even though these dollar amounts sound quite large that are being awarded to plaintiffs in these cases, they're really a drop in the bucket. They're a drop in the bucket for most city and counties budgets, and they're a drop in the bucket for most police departments' budgets. Sometimes I'm interviewed or talked to about these settlements, and people say, well, how, this doesn't seem right. Why should us taxpayers be paying hundreds of millions of dollars in these cases? And what I say back is, those hundreds of millions of dollars, they sound like a lot. They're less than 1% of most cities' budgets. That's what's being paid in these cases. Law enforcement agencies are taking a quarter to a third or more of cities' budgets. So I sort of resist the idea that we should be, I think that we need to be paying people when their rights are violated, and then obviously finding ways to stop people's rights from being violated. But I think that taking the money from the police department's budget, I don't think it will hurt because the dollars are so small, but I don't think on its own, I don't think that's, the switch that's going to change everything either. I don't know. What do you think, Amir?
Sir, please.
I don't think I have anything to add. I think I agree with that.
And I think that, just from a civilian point of view, that may be a small part of the budget, but that $100 million can be used for playgrounds, and it can be used for school counselors or whatever, so it's not so minuscule when we see it in those terms.
I completely agree. But then I say, why should the most vulnerable people in our population be fighting for that tiny pot of dollars? I talked to a lawyer who used to represent defendants employed by the city of Chicago. And he said to me, every time we had to pay a lawsuit, or every time we had lots of lawsuits, that meant less lead screening in public housing. And I thought, why is there one pot of money that is being divided by families living in public housing and victims of police misconduct. Why are those the dollars that this group of people has to fight for? And this is going to, the broader questions, sort of back to your point about Measure J and thinking about reinvesting, in communities. The idea that's I think that settlements and judgments in police misconduct suits are dollars going back to community members who have been harmed by the police. And I think they should be thought of in that way as well.
And
I feel so much better about that now.
Although it's public information, it's public information. We all know it's public information. The chances of us hearing about this settlement that's been paid out is in the small print in the back of the paper. They don't want us to know that the city's spending that kind of money or losing that kind of money on that type of litigation. And so it's very hard, unless you're following it, you don't see it.
Yeah.
I can't resist. There's another really interesting question here that Joanna and I and a professor at Cardozo Law have been chatting about a little bit, and I think it relates to this a little bit. At least one of the responses that I've gotten and that we get when talking about this, which is, there's no one forcing, at least in some sense, attorneys general, city attorneys to raise the argument of qualified immunity in the first place. In other words, it takes three actors here, right? There's the victim of the civil rights abuse or their family who's bringing the lawsuit. We have the judges who apply the law, but there's also the people who are representing the officers, who are often either a government attorney who works for the city in a lot of places, or sometimes the city farms it out to a private lawyer. But one question we should be asking ourselves is, why are they raising this defense in the first place? We have these progressive offices, at least, if we think about it at the state level, that are resisting in various ways. And someone asked a great question about the bipartisanship here, which I think we should answer and come back to. But just, there are these offices who believe themselves to be against, systemic racism and pervasive violence. And so why are they raising the arguments in the first place? And so there are some technical responses to that have to do with the ethical duties of attorneys to represent their clients. But let me shelve those for a minute, because I think that at least in a lot of places you can have answers to those. But often the instinctual response is, well, how are you going to convince a public official like an attorney general or whoever the elected official is that they should, add this to their budget, these paying people for these sorts of lawsuits? How are you going to convince someone to do that? And the answer I have is that's exactly what they should do. I mean, that's exactly what we're talking about here is accountability, right? And so by responding, well, how could you possibly expect me to add that to my budget? You're just saying you reject the idea that we should have this sort of reform. You're just telling you disagree with me, because the argument we're having is, are you going to be held accountable for what happened? Are you going to have a system in which there's feedback for your officers? And so we do often get this instinctual response of good luck convincing someone that, and why should they be convinced? And the answer is they should be convinced because that's the discussion we're having is accountability, and in this case, financial accountability, to make the system work at least a little bit better.
Thank you. Another question, Stan?
Yeah, is there a difference between qualified immunity and failure to comply with public policy? For example, if there are rules established for the county jail where employees do not follow such rules, that results in a violation of civilians' constitutional right. Also, is there a violation of privacy rights to have cameras in jail cells?
Wow, it's a lot.
Well, I'll take one little piece of it, and then I'm going to give Amir the scraps that are left that I don't know what to do with. So one thing that I would say is that I think is really important is that qualified immunity. Well, the Constitution does not give you a right to sue for violating police department policies. If there is a policy on the books that you have to do something a certain way, and an officer violates that, that does not mean that they've violated the Constitution. So I sort of, and that's true about, you know, qualified immunity as well. I mean, you could find cases, and, you know, maybe Amir's argued this, but you can find cases where violation of policies can be used as evidence that officers should have known that what they did was unconstitutional. So if the policy itself is consistent with what the Constitution requires, and then the officer doesn't follow it, the fact that the officer should have known about the policy can be used, unclear how successfully, but they're not one and the same. And if a local government decides to write policies that are stricter than what the Constitution requires, it's not a constitutional violation not to follow those rules.
Anything to add, Amir?
Yeah, and there are 3 levels here. I mean, you know, policies, proving a violation of a policy, all that gets you is the ability to complain often to the jail itself and have them remedy it. It doesn't prove a constitutional violation. And then, as we've been discussing today, even if you prove a constitutional violation, it doesn't get you all the way to a civil remedy, because you have the added hurdle of qualified immunity. So what you've got to prove at the end of the day is something much greater than that, which is a violation of clearly established law. I won't get into the very specifics of privacy rights dealing with, you know, cameras in jails. I'll say, generally speaking, there's not a lot of privacy in jail, not just cameras, but physical intrusions that have been upheld by courts. You lose a lot of rights, particularly in prisons, but also pretrial detainees do the second they're in custody. And there are a lot of live issues being litigated on that front.
Good.
And there's another question here, and it's pretty interesting. I recall in summer seeing a study linking a positive corrections officer's complaints and officer misconduct, such that most officers who prompt lawsuits and disciplinary action had a significantly higher number of complaints. To what degree do you view police unions' protection of substandard officers a contributing or not factor to abuse of power cases? And it's to me, it's like an officer gets fired from one city because he's brutal in the streets, and he goes to another city, and that cleared that up. But it doesn't, because he's brutal in that city too. And so within the own structure of one department, how do you feel about a bad officer continually being a bad officer and so on?
Yeah, I think this is a symptom of the problem we're talking about. It is certainly true that we often find in these cases that there is a history of bad conduct in the officers, and nothing has been done. And often it is the kind of revolving door that you know, the conduct happened in another police department, yet this, you know, officer was hired by a new office, maybe even promoted after that. You know, one thing this connects to for me is also just the ability to hold cities themselves liable. Forget suing the individual officers, which is how a lot of these lawsuits end up taking place, but suing the city for these kind of widespread practices of hiring officers, having, you know, no policies in place, poor training and supervision of officers. And that is another issue that we haven't really been talking about in this today, that is itself a very difficult thing to do because of the degree of kind of pattern and practice you have to show that cities have engaged in before they even become liable under a doctrine that's called Monell, named after the key Supreme Court case dealing with when you can hold municipalities liable or the actual entities liable for conduct. And I think, you know, part of the potential solution here is to just get rid of all these fictions, get rid of this idea of even pattern and practice, get rid of the idea of suing the individual officer, and just have kind of a more traditional liability that we think of with ordinary employers, that you're responsible for the actions of your employees when they take place in the scope of employment. And again, it kind of comes back to the idea that why are we treating police officers different? than others, and not expecting them to follow the law.
Well, we've sort of explored some of those issues in this series in terms of why police officers are treated differently. And part of it has to do with the myth of policing, you know, that cops actually stop crime and that they have these superhuman powers where they can detect if you're lying or not. You know, there's a whole bunch of stuff that is involved in that. But I don't think there are any more questions, and I want to thank you. I promised you we'd get you out of here on time, Joanna, and we do appreciate your time. Amir, you stay warm, and you can come out of your bunker now. And we totally appreciate you all.
Thank you so much for being here.
Very enlightening. Thank you.
Thanks for having us.
Yes. Have a good evening.
Thanks.
Great conversation. Thank you.
Thank
Bye-bye.
you, Anna Mary.